Can Ripple beat the SEC? When will Ripple present new arguments in its defense? How much will XRP cost after the trial ends? We will answer these questions in today's video. In the meantime, subscribe to the channel and we're getting started. The long-running legal brawl between Ripple and the U.S. Securities and Exchange Commission edges close to an end. In a tweet today, top U.S. defense lawyer James K. Filan informed his over 138 followers that as of January 19, 2023, everything is briefed in the lawsuit. This suggests that the parties, Ripple and the SEC, have made the necessary filings, including motions for summary judgment and motions to seal all materials relating to the summary judgment motion. Filan's tweet comes as part of efforts to update the XRP community on the scheduling updates of the lawsuit. An excerpt from the attached image read, "Now we wait." Judge Annalisa Torres is currently reviewing the multiple briefs filed by the parties before making a final decision. Reacting to the tweet, XRP community members took to the comment section to express gratitude to Filan for keeping them updated throughout the lawsuit, which has lasted for over 2 years. Attorney Jeremy Hogan, a partner at HOGAN law firm, was among those who expressed gratitude to Filan for his efforts in keeping the crypto community updated. XRP community attorney John Deaton also reacted to the latest scheduling updates shared by Filan. Deaton referred to Filan's latest Ripple v. SEC lawsuit tweet as the best update ever. In December 2020, the SEC dropped a bomb on the crypto industry by suing Ripple and 2 of its executives, Brad Garlinghouse and Chris Larson. The Securities and Exchange Commission claimed that Ripple and its execs sold unregistered securities in the form of XRP. The case, which Forbes dubbed the cryptocurrency trial of the century, is expected to set a precedent for the future of the U.S. crypto market. A win for Ripple could pave the way for regulatory clarity in the United States. However, a ruling in favor of the SEC could give the regulator a powerful weapon to go after other cryptocurrency projects. In previous updates, Filan has predicted that Judge Torres would likely make a final decision on the case before the end of March 2023. Meanwhile, Ripple's CEO recently told CNBC that he expects a final resolution of the company's legal brawl with the SEC to happen in the first half of this year. Garlinghouse added that he is confident about the outcome based on Ripple's position with the law. The case is now fully briefed in front of the judge. We are optimistic that this will certainly be resolved in 2023, maybe the first half. We'll see how it plays out from here. But I feel very good about where we are relative to the law and the facts, he remarked. As reported by the Crypto Basic in Davos, Ripple CEO said that people will be stunned at the SEC's behavior when Hyman's emails come to light. The U.S. Securities and Exchange Commission, SEC, lawsuit against Ripple Labs is not the only battle the company is currently fighting. In fact, there's a court case that has been under trial for a longer period of time. The class action lawsuit filed by XRP investors against Ripple Labs and CEO Brad Garlinghouse, which has been pending since November 2018. The case, which is being heard in the U.S. state of California, is led by lead plaintiff Bradley Sostek, with 3 lawsuits, Zakinoff, O'Connor, and Greenwald. Consolidated into one, the plaintiffs accuse Ripple of selling XRP as an unregistered security and seek damages for losses suffered from the sale and alleged promises by Ripple. In addition, the plaintiffs are asking the court to also classify XRP as a security. Attorney John E. Deaton, who is already involved with a respective amicus brief in the Ripple vs. SEC and Elbree vs. SEC cases, is now getting involved in this case as well. As prominent criminal defense attorney James Filan writes in a series of tweets, Deaton is filing an amicus brief in Zakinoff vs. Ripple. Filan writes that the proposed class would include XRP holders around the world, including the 75,890 holders in the SEC case who have joined Ripple's arguments and disagree with the plaintiffs in Zakinoff, saying that XRP is not a security. Moreover, the proposed class action is not limited to direct sales by Ripple, but extends to all sales of XRP, including secondary sales and international sales in countries where the token has already been classified as not a security. Deaton argues in his motion that the court should not certify the class because of these conflicts and because there are only a small number of holders who claim that XRP is an unregistered security, while vastly more token holders worldwide claim that it is not. Just added to our document library, order granting John Dayton on admission pro hacks, vice representing XRP holders in U.S. District Court for Northern District of K in Ripple Labs into litigation. Link to order. Fred Rispoli, also an attorney from the community, commented on Deaton's move with applause, saying, "Being familiar with class actions, the class certification battle is the most important fight in these types of cases. John coming in here in this capacity is a real kick in the balls top." Plaintiff's counsel, and I don't disagree with John, but the ball kick cannot be overstated. For his part, Deaton commented on Filan's announcement on Twitter, saying, "Whether it's the SEC or a plaintiff's attorney making the absurd argument that secondary market transactions of a token are also securities simply be it may have been previously offered or sold in a way that violated Section 5 of the Securities Act, I'll see you in court." Publicity-hungry Twitter lawyer John Deaton recently boasted about getting the U.S. Securities and Exchange Commission, SEC, to declare on record that LBRY's LBC token is not a security. Many saw this as a hint that the big bad SEC had been put in its place for overreaching, and that Ripple, another business fighting the U.S. regulator over an alleged unlawful securities offering, may win. Deaton exaggerates, and XRP in any future crypto product will be unaffected. The SEC defeated LBRY months ago. A U.S. federal court concluded that LBRY's LBC token sale was an unregistered securities offering and unlawful. The SEC never called LBC a security. As Deaton notes, Howey cases are about whether the item was offered as an investment contract, not whether it was a security. Investment contracts are securities. LBRY and Ripple are SEC cases. Given that LBC's original sale was unlawful, may bag holders resell tokens on the secondary market. The SEC's proposed phrasing might ban LBRY's direct and secondary sales. The SEC seems unwilling to agree that any secondary market sale would not violate securities laws in court argument. Deaton entered. Naomi Rockwell, a crypto journalist, possesses 261,500 LBC tokens from the secondary market. No LBRY tokens were bought. As an amicus curiae, she asked the court if its LBC token ruling would restrict secondary market sale. Deaton represented her. If not, reject the SEC's wording. Deaton represented Rockwell in a remedies hearing last week. On his own program, Deaton pointed the judge to the widely distributed Lewis Cohen article, which examined 7 decades of securities case law and concluded that the asset underlying an investment contract has never been considered a security. Thus, any SEC order should not prevent LBC holders from selling tokens on the secondary market. Deaton claims he won many industry wins here. That's exaggerating. The SEC would have acknowledged that the pure situation of a wholly independent resale of tokens, the first selling of which was unlawful, is not a securities offering. The SEC never disagreed. Their legal documents confirm. The SEC has repeatedly said that the LBC token is not a security. Therefore, Deaton's on-record claim is meaningless. The SEC's hesitation to declare that no secondary sale constitutes a securities offering is justified. The LBRY case has always been about LBC token sales by LBRY, not secondary sale. The SEC may have submitted an unclear order, but as its documents show, it never intended to make any assertions regarding secondary sales' legality. The court asked the SEC about a simple transfer from one party to another, which the SEC properly recognized would not be a securities offering. However, this does not indicate that no secondary sale could ever be a securities offering, as Deaton claimed. Secondary sales may violate securities laws. Transaction type matters. The judgment does not affect the fact that LBRY's first offering was an unregistered securities transaction. That's why XRP is under fire, and the LBRY lawsuit won't impact Ripple's liabilities for its first XRP sale. Ripple officials pledged to develop secondary markets to boost the coin's price. which the SEC claims triggers the Howey test's expectation of profits depending on the actions of others prong.